today about the last panel of the 4-day Sarajevo session program. Today panel is special panel, Srebrenica and Gaza panel. As you know, this year is also the 3rd year anniversary of the Srebrenica, and as the steering committee thought maybe it is good to put any kind of Srebrenica program in the Gaza Tribunal Sarajevo session because it's the same as a genocide just 30 years ago in Sarajevo, in Srebrenica. We will have, we are planning to have 3 speakers for this panel, but unfortunately just Arnesa informed us last minute she was sick and she will be not here today. And so we will have 2 speakers for this panel. I want to introduce them to the stage. First panelist is Harun Halilovic. Harun Halilovic is assistant professor at this university, law school. He holds a baccalaureate in law from University of the Sarajevo and an LLM from Queen Mary University of London. He obtained PhD in law from the University of Tuzla Faculty of Law. Before to joining International University of Sarajevo, he was a practicing lawyer. He is author of 2 books as well as several articles published in the international indexed journals. Please welcome Harun. Our second panelist, Mustafa Çeriç. Mustafa Çeriç is currently president of the World Bosnian Congress. He has a PhD degree in Islamic Studies at the University of Chicago. He served as the Grand Mufti of Bosnia and Herzegovina. He is also a very patient activist and among many other social and global issues. He is quite concerned and actively involved in what's happening in Gaza. Please welcome Mustafa Çeriç for the panel.
I would like to welcome you all here present and of course online. We are today starting with the Srebrenica panel, also linked with Gaza. And me as the first presenter, I'm going to talk about the topic of litigating genocide. So as we know, the most common venues of judiciary processing of the genocide are through the criminal courts and through establishing of the state responsibility in the venues like the ICJ. But often overlooked venue is actually the establishment of the civil liability, liability for the damages in the civil proceedings, and questions which need to be resolved prior to the determination of the damages and the obligation to pay the compensation of the damages, the question of state responsibility. So I am going to talk about a very interesting case, the case of Mothers of Srebrenica versus Netherlands, and its potential implications to the application of the international law and to the, of course, to the Gaza. So next slide, please. So what are we talking about? The Supreme Court of Netherlands in July 2019 adopted a decision in the case which was initiated by the relatives of the victims of the Srebrenica genocide. The decision found that the state of Netherlands is partially liable for the death of around 350 victims of the Srebrenica genocide that were located and later evicted from the Potocari compound, the Dutch but military compound, and given up into the hands of the army of Republic of Srpska and later killed. The decision has its special significance since it reaffirmed the possibility of the dual liability of the state acting under the UN mandate. However, it reversed or lowered the responsibility of the state, which was first determined by the lower courts at the 30%, to only 10%. So, next slide. So, of course, the background of the case is Srebrenica genocide. Some of the facts are very well known. So, in 1903, there was the first initial Security Council resolution proclaiming the safe area of Srebrenica, and in 1904, the Netherlands army contingent arrived at the Srebrenica, the Dutch bat, and they were garrisoned in the Potocari compound. And as we all know, in July 95, after a heavy military campaign, the Srebrenica was overrun by the army of the Republic of Srpska. At those moments, the civilian population en masse made its way to the Potocari near the Dutch bat compound, requesting the protection from the Netherlands forces as per the Security Council mandate. While doing that, some 350 residents of Srebrenica were at the Dutch bat compound on various grounds. Some of them were working for the Dutch bat as interpreters, as technical support. Some of them were members of their families. Some of them got their way into the compound. So Dutch bat lacking support, for which one have to mention nobody was held accountable. They decided not to react, and ultimately they abandoned the Srebrenica and its people, and basically taking their own safety as the priority instead of the mandate that they were given. Okay, next slide. So when we are talking about the proceedings in this particular case were initiated in 2007 in front of the District Court of Hague by the relatives of the victims of the Srebrenica genocide against the state of Netherlands and the United Nations. So they were initiated as the civil suit requesting the determination of the responsibility of both State of Netherlands and the United Nations, and requesting payment for the compensation of the damages suffered by the loss of their relatives. The lower courts found that the liability can exist, the dual liability can exist, and the liability of the State of Netherlands, acting through its Dutch bat being the agent of the state in this case, does not prejudice or determine the liability of the United Nations, finding that the case against the United Nations is inadmissible. So it actually follows the string of the cases like the Nuhanovic case, which also determined the possibility of the existence of the dual liability of the state acting under the UN mandate. The inadmissibility against the United Nations was actually upheld by the European Court of Human Rights, which referred to UN Charter and the Convention on the Privileges and Immunities of the UN, stating that UN cannot be tried in front of the national courts for the grounds of preserving their impartiality, declaring therefore the case as inadmissible. So when we look into the reasoning of the decision of the Supreme Court of the Netherlands, so the Supreme Court of the Netherlands, deciding on the appeal, reaffirmed the line of reasoning of dual attribution of the responsibility, determining that the Dutch bat, as the agent of the state, has exercised personal jurisdiction and had effective control over the victims. Now, the Supreme Court of Netherlands limited the liability or responsibility only to approximately 350 persons that were in the Dutch-Bite compound that were later evicted, and reduced the amount of responsibility from 30% to 10%, stating that the victims would have only 10% chance of survival, even in the case that they were not, even if they have not been evicted. So, of course, this decision can be described as one step forward, 3 steps back, because on one hand, it determines some degree of liability. However, that liability is heavily limited, and one can identify several contentious points in that decision. Well, first point that is problematic is, of course, the determination of the percentage of the responsibility of the State of Netherlands, because both numbers, 30% and 10%, are arbitrarily set. They are based on speculations, and the decision on choosing either number is not well reasoned, because one can also argue that if those persons were taken with the together with the Dutch bat when they were leaving the compound, then in that case their chance of survival would be 100%. So any number, both 30% and 10%, are based on speculation. So, and of course, the limitation of the responsibility only to those approximately 350 victims that were found within the compound it goes against the logic of the case and the facts of the case, because the vast majority of the civilian population made its way to Potocari to demand the protection from the Dutch bat, not on basis of any illegitimate expectation, but on the basis of legitimate expectation of their mandate that was ordered by the UN Security Council. So, and ultimately this decision creates the division between the victims and shifts the onus of the proof to the victims. So now they have to prove that their relatives were within the compound, and they have to prove it to the so-called Netherlands Compensation Commission Potocari, which up until this moment paid some compensations to those who have proven that their relatives were among those within the Dutch bat compound. So legally analyzing this decision sets a very negative precedent for the international law, because it stated that the UN Genocide Convention does not provide for the direct effect which would enable citizens to initiate civil suits and request the compensations of the national court in front of the national courts. However, when analyzing the decision, it can be inferred that the responsibility of the state of Netherlands was determined by the wrongful act of giving up of the persons who were under the effective control of the agent of the state, that Dutch bat, to the non-state actor, the Army of Republic of Srpska, for which the state of Netherlands is not responsible based on the doctrine or the principle of Nicaragua, which states that in the ICJ case of the Nicaragua against the USA, which states that the limits of the state liability for the actions of the non-state actors is limited to the extent of the effective control the state has over the non-state actors, and the whether the non-state actors were acting under the effective control. This application of this standard and this doctrine was also very contentions in the very decision of the ICJ in the case of Bosnia versus Serbia, which ultimately decided that Serbia was not directly responsible, but responsible for non-prevention of the genocide in Srebrenica. But although this reasoning is correct, the same way it is unlawful act for a country, for example, to extradite somebody to a place where they can face death penalty or similar situation, it only answers the question of how the state of Netherlands exercised the jurisdiction, the personal jurisdiction over the victims. The Supreme Court of the Netherlands is avoiding the question of why was the state of Netherlands and the Dutch BAT as the agent of the state involved in the Srebrenica at all. And the answer to that question is, of course, they were fulfilling the United Nations Security Council mandate of protecting the people of the safe zone of Srebrenica, which in terms leads us to another question. Well, why was that mandate established in the first place? And that mandate was established in order to prevent the occurrence of the large-scale war crimes and even genocide, because we have to remember that the case of Bosnia-Herzegovina versus former Yugoslavia was initiated in 1903, and shortly after there were provisional measures similar to the ones that we have in the case of South Africa against Israel, which indicate the risk of genocide, possibility of genocide occurring. So legally speaking, that point is of a very great significance, because it indicates a point which triggers the duty to prevent genocide. And well, talking about the duty to prevent genocide, it is a well-established obligation under the international law, which is defined, of course, primarily by the Article 1 on the Genocide Convention. However, that obligation is especially reaffirmed in the Bosnia versus Serbia case, or the Bosnian genocide case, which ICJ, in its judgment, in the paragraphs 430 and 431, in very strong terms, defined as a strict obligation, which is far-fetching. So the ICJ, in its judgments, concluded that the state cannot be under the obligation to succeed in preventing genocide. So it is not expected for the state to prevent the genocide. However, the states are under the obligation to employ all means reasonably available to them to prevent genocide as far as possible. So meaning all the actions that they can do, which are in their power, that could contribute, or if withheld, could contribute to prevention of the genocide, the states are under obligation to perform those acts. And the moment when the states incur this obligation is, this obligation is not triggered, it does not come into being when the perpetration of the genocide commences. Because, as we know historically, during the commission of the genocide is denied. The genocide is hidden away. It's so the court concludes that that would be absurd, because the whole point of the obligation is to prevent, or attempt to prevent, the occurrence of the act. So the state of the state's obligation to prevent arises at the instant the state learns, or should have normally learned of, the existence of the serious risk that the genocide will be committed. And we mentioned that this point, legally speaking, it can be inferred that it especially exists after the point of the adoption of the provisional measures by the ICJ, which which indicate to very minimum the risk of the possibility of the genocide. We know that, especially in the case of Gaza, we are way past that point. So when talking about the duty to prevent genocide, one especially interesting case, one to follow, one that can leave many implications to the international law and also ultimately to the possibility of request of the compensation, is the one that is actually initiated again in front of the ICJ by the Nicaragua in March 2004 against Germany. In that application, the Nicaragua is claiming that Germany, by its long-term financial, political, logistical, and military support to Israel, is actually infringing on the duty to prevent genocide, which, as we said, is especially arises especially at the point of adoption of the provisional measures which indicate, to say the very minimum, the risk of the occurrence of the genocide. So the interplay of the facts in this case and the decision of this case can be very, very wide-fetching. But especially when we look at the facts of this case, in this particular situation, the ICJ cannot really rely on its, let's say, the old friend, the Nicaragua standard or the Nicaragua doctrine, because we have a state of Germany supporting the state of Israel. So so the line of thinking of state liability for the actions of the non-state actors, which was the problem in the Bosnia versus Serbia case, which was ultimately mentioned even in the Mothers of Srebrenica case, is not applicable in this case. And of course, the far-fetching implications are in those that it opens the doors for other similar applications against other states for the support of the Israel and for failing the duty to prevent genocide. And of course, if the decision of the ICJ turns out to accept this application and this reasoning, the implications for the possibilities of the claims of damages against these states is very, very wide-fetching. So, as we said, this is a very also important case to look at, and especially in the case that the ICJ, for example, decides to reject this application. Well, in this case, the ICJ has to go against its own wording, which is very strong wording and very expansive in defining the obligation of the duty to prevent, as we have seen in the paragraphs 430 and 31 of the genocide of the judgment in the case of Bosnia versus Serbia. So these situations. Okay, I'm finishing. So this case, as we mentioned, is of a great significance, and its implications can be far-fetching, both in determining the responsibility of the state and in the determination of the duty to prevent genocide. And especially if we are talking about the possibilities of the request of the compensation for the victims, which could potentially follow later. So that was from my side. Thank you very much, and I'm thanking to the to our listeners online.
Thank you so much, Harun, for this presentation. Now our second panelist, Mustafa Çeriç, Yes, please, Mustafa.
Assalamu alaikum, good morning. İyi günler. I'm honored to be with you today. Even though you are few, I think I may say you are selected. So thank you for your selection. So far, we humans have only one brain. And it is designed by God to communicate with human brain, similar to our brain. But I think in the future, I would not interfere in God's business, but I expect that God will create two brains so that one brain can communicate with the human brain and the other brain can communicate with AI brain, so that we can at the same time that we can use both brains when one speaks, and also the other brain to be occupied with AI brain. Because this human brain is becoming boring. It's not exciting. And this AI brain that we are using all the time, it is exciting. And our human brain is learning and is now eager to receive only exciting information. I am not sure that I can give you by my human brain exacting information that will attract your attention. But I would say and share with you something that you know. So it's going to be boring, but I have no choice but to expose you to my boring speech. Last century, 20th century, is the most dramatic century in the human history. In that century happened everything that human can imagine and cannot imagine. Among other things, last century witnessed three unimaginable, but real events in the human history. One is Nakba, 1948. The second is Holocaust in 1945. And the third is genocide in Srebrenica. So, for example, 27 January is the day of remembering Holocaust, as you know, in the whole world. 11th of July is the day of remembering genocide in Srebrenica. Last year, 2024, on 24 May, United Nations adopted the resolution by which the whole world accepted to remember Srebrenica genocide. And this is very near and close now, the 11th July. 15 May 1948 was Nakba. Who remembers among us Muslims about this date? 15 May. Rare. But United Nations in 2003 adopted a resolution that the 15 May be Day of the solidarity with the Palestinian people of Nakba. On that notion, I asked my women in Bosnia to create this flower, which is similar to the flower of Srebrenica, which indicates on the 15 here, meaning 15 May, Nakba. But everyone knows about 27 January, about Holocaust. Everyone knows, or half of the humanity, about 11th of September, of 11th of July, but few people know about 15. And this here we are to speak about Gaza. So you ask me to say something about the comparison between Srebrenica and Gaza. But in order to understand and in order to introduce you to this subject, I would ask for your patience to give you some comparison between Auschwitz and Srebrenica. Let me say that in the span of a half century, two places, Auschwitz and Srebrenica, became symbols of the deepest moral collapse of humanity. In them, the human capacity not only to ignore the suffering of others, but to rationalize their annihilation was laid bare. In Auschwitz, in the heart of Europe under the cold regime of industrialized evil, the Holocaust was committed against Jews and other undesirables. In Srebrenica, at the end of the 20th century, under the gaze of the entire world, the Serbian army committed genocide against the Bosniaks, the worst war crime in Europe since World War II. Both crimes, though different in time, technique, and ideology, revealed the same darkness, the wicked nature of man. They showed that no matter how advanced civilization may be, it does not guarantee morality, that international law, however developed, does not ensure justice, and that democratic societies, however free, are not immune to indifference. Auschwitz was more than a camp. It was the symbol of rationalized evil. Nazi Germany turned the extermination of Jews into a technical task, a logistical challenge, an industrial project. Human beings were reduced to numbers, then to smoke. Planned, documented, archived, the Holocaust had the support of the state, science, administration, and industry. Conscience failed in Auschwitz not because it didn't know, but because it didn't want to know. The crime was too great to accept, so it was rendered invisible. Srebrenica, half a century later, was a United Nations safe zone. There were no gas chambers, but there were rifles and trenches. The difference was merely technical. In Srebrenica, people were killed after being disarmed under international guarantees. It was a betrayal of trust, of law, of humanism. The genocide was carried out in the presence of international troops who remained silent, mute before genocide. If Auschwitz was the crime of bureaucratized evil, Srebrenica was the crime of indifference, the crime of inaction. In Auschwitz, human conscience was murdered through propaganda. In Srebrenica, through silence and passivity. One was a structured project of death, the other a failure of the modern order to prevent repetition. The similarity between Auschwitz and Srebrenica is not in the method of killing, but in the message they carry. No one is safe when human conscience is turned off. Both places are black holes in the fabric of European civilization, places where institutions failed, where man became a means, where the value of life was measured by ethnicity, language, and religion. The difference lies in the world's reaction. The Holocaust became the foundation of the post-1945 international legal order. The Genocide Convention was born. Tribunals were established to prosecute crimes against humanity, and the human rights education was launched. Yet, Srebrenica happened despite all of this. All the declarations, resolutions, conventions, they were present but ineffective. This reveals the harshest truth. Laws are not enough. There must be the courage to enforce them. The law is not in the books. The law is in the heart. Both phenomena warn that evil is not born out of ignorance, but as a choice. People chose to serve the system in Auschwitz. People chose not to act in Srebrenica. Both were choices, and therefore the responsibility is moral, not merely legal. Today, as we live in an era of rising populism, genocide, denial, and the relativization of history, we must clearly say Auschwitz and Srebrenica are not merely tragedies, they are tests of humanity. We failed them both, but an even darker future would be one in which we learn nothing from those failures, as we see now in the case of Gaza, Palestine. Auschwitz and Srebrenica stand as two monuments to human shame. The first taught us that evil can be systematic. The second, that evil can be left to indifference. One is the reason international law exists. The other are a reminder that law without courage means nothing. If we owe anything to the martyrs, to shaheeds, it is to be better for living here and now. Now, let me now say how I feel about between Drina River and the Gaza Strip, comparative genocide of our time. Where justice ends, history begins, written in the blood of the innocent. In the long corridors of history, of human history, there exists silent gallery of suffering, portraits of nations erased under the weight of violence, their bones buried beneath skies too worried to pray. Among these shadows, two tragedies echo with haunting clarity: Srebrenica, the heart of Bosnia, and Gaza, the bleeding wound of Palestine. Two peoples, two geographies, two eras, and yet one shared sorrow, one silence, and one eternal question: how can man do this to man? Srebrenica, July 1995, a united, declared safe zone. Under the different gaze of the international community, a systematic massacre genocide unfolded. Over 8,000 Bosniak men and boys were executed in a matter of days. It was the most heinous mass killing in Europe since World War II. The International Criminal Tribunal for the former Yugoslavia legally recognized the events as genocide, and perpetrators, including Radovan Karadzic and General Ratko Mladic, were convicted and sentenced in The Hague. Gaza, 21st century, a tragedy not frozen in time, repeated in cycles of destruction. Israel military campaigns, especially in recent years, have resulted in thousands of civilians' deaths, children, women, the elderly, buried beneath rubble. While the Israeli government claims self-defense against terrorism, numerous UN bodies, legal scholars, and human rights organizations have raised alarms over what may constitute a genocidal pattern of conduct. Unlike Srebrenica, Gaza awaits its courtroom, its verdict is justice. Genocide, as defined by the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, is the international destruction, is the intentional destruction in whole or in part or a national, ethnic, racial, or religious group. In Srebrenica, this legal standard was met and confirmed. The intent, the planning, and the execution were methodical. It was an act committed by state actors with military precision and bureaucratic support. In Gaza, the legal discourse is still evolving. Some characterize Israel's actions as defensive. Others argue that systematic destruction of civilian infrastructure, repeated mass killing, and explicit rhetoric from state officials point to genocidal intent. The International Criminal Court has opened preliminary investigation, but no formal recognition of genocide has yet occurred. This tragedy transcends legal terminology. It is epic in scale and deeply human. It mirrors the timeless battle of David and Goliath, of a stateless people facing a militarized machine. In Srebrenica, mothers buried sons in mass graves. In Gaza, mothers carry limbless children through dust and fire. In both, the silence of the dead cries louder than the noise of bombs. Legal status in Srebrenica, genocide enforced by ICTY, Gaza, alleged genocide under legal security. International response, UN inaction followed by trials in Srebrenica. Mixed responses, ICC investigation ongoing. Time frame, besiege of Bosnia, Sarajevo, 1,425 days. Result, genocide. Gaza, prolonged recurring cycles of violence, genocide. Civilian death toll, 8,000 in few days. Palestine, Gaza, tens of thousands over 2 decades. Symbolism, Srebrenica, mass graves, white headstones. Gaza, ruins, orphan children, starvation. If the genocide in Srebrenica is Europe's scar, then Gaza is humanity's Homer-hedging conscience. What Bosnian Muslims experience as the humiliation of erasure, Palestinians endure as a drawn-out annihilation. Both peoples live with the burden of being reduced to numbers in reports rather than humans with names and dreams. But the justice is not a moment, it is a process. And the process begins here, in speaking the truth, in naming the crime, and in seeking justice, not for vengeance, but for the dignity of those who remain and those yet to come. In Srebrenica, silence became a tombstone. In Gaza, streaming becomes background noise. It is now up to us, defenders of law, to transform silence into justice, not out of retribution, but in the name of the future. Did you notice that 2 genocides are against Muslims in Srebrenica and in Gaza? Who are we Muslims? Why they kill us? Are we really problem for this civilization? How can we overcome, or shall we overcome, these attitudes toward us, that our blood is cheap, but our oil is very not cheap, very expensive. So may God help my brothers in Gaza, and if they hear us from here, we will join our voices as many hopeless voices in the world, like crocodile's tears. But please, we ask your sumud so that you save us too. We are doing this conference here not because of you, but because of us, to clean up a little bit our guilty conscience. Thank you very much.